getting a court order.
And Your Honor, at the last hearing, I did mention, and of course, I would like to go ahead and go into my argument, and I'm going to go ahead and ask that the court allow me to make a full record.
Okay, go ahead.
And so, just again, first of all, responding to what Your Honor has been saying, in my motion to compel, I very clearly stated that I was actually remaking my request as a motion to compel discovery, not as a motion to, have subpoenas enforced.
Okay.
So the requests were in the body of the motion. We are not talking about trying to enforce subpoenas here. As Your Honor had mentioned at the last hearing, when, as far as Your Honor is concerned, I am to ask Your Honor to order that documents be compelled.
Mm-hmm.
And that is what I did in the motion. But I don't know if, again, Your Honor read it because you still say that it was inappropriate. But it was in the motion. So to just go on, beyond the fact that, again,
You can't compel other people to give you discovery, like you're trying to get things from other individuals.
Your Honor.
So in order to do that, you need a court order.
And again, so I guess I'll just make my record, if I may.
Go ahead.
Okay, so first of all, again, I have to note that the court refused to grant me continuance. The court has granted other attorneys continuances with no problem. In fact, my own attorney at the time, Ryan Helmick, on November 10th, 2022, requested a one-week continuance when he had a motion that was brought by a third party that he had sat on for about over 10 days. And the court still had granted a continuance there. The court refused to extend that same courtesy to me. Also, as just observed, Your Honor tends to cut me off when I'm in the middle of speaking. And I've observed that Your Honor does not do that with any other attorney. Your Honor does not do that with victim witnesses. In the entire time that I've been in this courtroom, it appears that I'm the only person who gets cut off while in the middle of trying to say anything. And then, of course, there's the fact that Your Honor engaged in a re-examination of my indigency, based apparently on hearsay about news articles. There was articles that Mr. Hammer had mentioned that Your Honor decided were apparently sufficient cause to engage in that re-examination. Because, as far as I know, Your Honor has not re-examined any indigency ever for standby counsel. Now, perhaps for a witness motion, but I am all but certain that Your Honor has, for the first time ever, re-examined indigency for standby counsel in my case. So I'd like to go ahead and go on to the argument regarding my request. Now, as far as the requests go, like I said, they were actually made within the motion. So any order that denies the request should deny the request within the motion, not deny the subpoenas. And of course, if Your Honor wants to quash the subpoenas as well, that's fine. But again, as Your Honor stated, that I should be giving these requests to you for you to order them if you so see fit. I did that in the motion. So right now my concern is that there was nothing in the response to actually address each of those individual requests that I made. And so I do have arguments that I was going to go ahead and put into reply that I will have to put on the record here and now. My first request that I made within my motion was regarding a request for consideration of rehousing. And in that request, amongst other things, I made a request for video that would show that the officers of CCDC engage in cruel and unusual punishment. In that video that I am requesting, you can see that a senior citizen is placed in a lit room overnight from 7 to 7 for, again, pretty much the entire night, with no blanket, no mattress, no pillow, because he upset or irritated an officer for all of a couple of minutes. I was not far from witnessing this incident. And so that issue, again, is something that I will need when I file for reconsideration or even a writ. The next issue the second request, relates to the body search, buccal swab, and interrogation. And I'm requesting those items to demonstrate that Detective Gaddis is spelled G-A-T-U-S, lied in the search warrant affidavit. Detective Hawkins Hawkins, sought a warrant to seize my jeans for the sole purpose of enhancing interrogation. And this will demonstrate as well that I was unlawfully detained at the Summerlin Area Command for over 7 hours against my will. The third request relates to items demonstrating the officer's use of a stingray, also known as a cell site simulator, without a search warrant. Now, Detective Gaddis stated in a search warrant that, I quote, he walked back in and his phone stopped receiving signal. Tellis exited the home again and began to watch the maroon GMC Yukon Denali. Tellis's phone turned on a short time later. End quote. I never turned my phone off. So that there shows that what was happening was my phone was switching from connection to their cell site simulator, their Stingray, to my actual Wi-Fi. So, and frankly, this is an issue that, because this was done without a search warrant, it's an issue that all Clark County residents should be concerned about. Because what this says is that there are actually officers out there who have these devices in their possession who have no accountability as to how they are used. There appears to be no equipment custodian because, again, there was no search warrant. So it should be concerning to all of us that these stingrays, which can capture text messages, emails, phone calls, that the actual content of the conversations are being used by our officers without any real oversight, and they could be used easily for personal use and abuse. Fourth, I have requested the video and the notes from the surveillance done at my home on 9/6 to show that Detective Gaddis lied when she declared that I engaged in suspicious activity that night. She essentially alleged that I was trying to destroy evidence by doing an exterior wash of my Yukon SUV. She clearly detailed events in a way where she omitted the fact that I washed the exteriors of all 3 of my cars, and I did not vacuum or shampoo my cars, any of the interiors. However, she phrased the search warrant in a clearly false way to indicate that it looked as though I was washing the exterior of my car to destroy evidence. And by stating just one vehicle, misleading the judge, Tiara Jones, when she presented the search warrant. Fifth, I requested all the tips provided to Detective Gaddis by other officers. I believe that Detective Jaffe, that's spelled J-A-P-P-E, may have provided the tips that Detective Gaddis claimed were actually provided anonymously. Sixth, I requested the time at which certain events occurred to demonstrate that Detective Gaddis and Detective Hawkins lied and also omitted certain information in their sworn affidavits to the judges. Seventh, I requested all information relating to the impound of my 3 vehicles to demonstrate they were seized before search warrants were issued allowing for seizure. Eighth, I requested all documents surrounding Detective Gaddis' claim she received my phone records from other detectives. A search warrant for my phone records was not actually obtained for my phone until September 16th. Therefore, Gaddis illegally used records that she obtained for the purposes of obtaining a search warrant. Also, the vehicle search she alleged that she had done, also within the same search warrant, indicates that my car, my wife's car, was a vehicle on the list. However, this list, based on later evidence that she provided in discovery, or that the DA provided in discovery, shows that they were still trying to identify a day later the year of the vehicle. So we're talking about a list that, if she truly provided that list, printed that list, should have models from 2007 to 2014. So it should be an extensive list. But the way that this search warrant application was written, she made it sound as though it was a short list and my wife's car was on it. And that was done to pad her probable cause. Ninth, I am seeking the CAD log unit reports by unit. Now, these are reports that are provided to track what officers are doing, where they're at, what their current status is. And the state had provided to me certain CAD log units. Interestingly, from, I believe it was the 3rd and 4th of September, there is activity by Detective Gaddis listed. However, the day of the arrest, her movements were not on any of the reports. The movements of Detective Jaffe were not on any of the reports. And I'm certain that the reason that they obscured their movements was they wanted to hide the truth about when the search warrant was actually obtained, because it was obtained after the traffic stop had occurred. And it'll also demonstrate that they unlawfully held me at Summerlin Area Command. So that is why I'm certain that they hid this information. 10th, I am seeking all search warrants and related materials to show the full extent of the perjury and illegal conduct. Further, it appears Gaddis intentionally sought, and this would be on the morning of 9/7, a search warrant at 2 a.m. Now, she claims, as one of the linchpins for her search warrant, is that on 9/6, again, I engaged in this washing of a vehicle. Now, this is probably somewhere around 7 o'clock p.m. Yet Gaddis did not obtain this search warrant for a GPS until 2 a.m. That would mean that Gaddis is a very slow typer, or, I can't begin to speculate why it would take, well over 7 hours to, get a search warrant out. Or I should say, But regardless, at 2 a.m. there was an application for a search warrant for a GPS that was submitted to Judge Tiara Jones. And that was at 2 a.m. for a GPS. And hours later, a much more intrusive search warrant was requested and issued. It is my belief, and again, this is why I'm requesting materials to see about communications, that Detective Gaddis intentionally drafted a search warrant for a GPS, which would be irrelevant days after a crime was allegedly committed, to do what? To say that this GPS is going to track the movements of this Yukon going forward? No. What it was that I can see, it was an attempt to soften up the judge at 2 in the morning, so that when she was contacted again later, at some time after 6 in the morning, that she would not have her full judgment in front of her to make sure that she actually signed that she reviewed what she signed. Why else would she, it just doesn't make sense, really. I see that you've got confusion on your face. So I'll just keep going. 11.
I don't know what soften a judge means.
Well, to get her used to the notion of the fact that, apparently, there is actually a reasonable suspicion, or there's probable cause, when there was not. 11, all video and notes from the traffic stop will show I was unlawfully pulled over and detained. Also, it will show that Gaddis lied about obtaining the search warrant before the traffic stop. 12th, I am seeking all materials related to the 2 search warrant affidavits submitted by Gaddis on September 7th, 2022, to show that she intentionally lied.
Okay, say again what you're asking for, the what?
Again, all materials that are related to the 2 search warrant affidavits submitted by Detective Gaddis on 9/7/2022. It's in the motion as well, Your Honor. Again, and this is to demonstrate that she intentionally lied and provided unlawful actions by officers as the basis for probable cause. 13, I am seeking the disciplinary records for Detective Gaddis and Detective Jaffe to determine either whether their conduct has been subject to disciplinary measures before, or if, and heaven forbid, these unlawful practices are ones that are typically condoned by Las Vegas Metropolitan Police Department. 14, I am seeking all communications between Detective Jaffe and Detective Gaddis to show that Detective Jaffe, a detective with whom I was working on a separate investigation that seemingly and mysteriously fell apart, was now very involved or even leading the investigation that focused on me. 15, I am seeking training materials, policies and procedures for certain subjects to demonstrate that Detective Jaffe and Detective Gaddis, who, by the way, have well in excess of 10 years of experience each, knowingly violated department policies as they were investigating this case, showing that it was not just and certainly with the volume of activity here, this certainly could not be seen as a mistake here or there. But again, as I'm sure this court would like, I want to make sure that I make a substantial showing. I'll note also for the record that LVMPD failed to address the content of my requests, likely expecting that this court will just deny my request outright on a wholesale basis, frankly because LVMPD said so. I would like to also note that LVMPD wrongly asserted that I have no intention of receiving exculpatory material from Mr. Gurman's devices, as though I said I never wanted it. In my motion, I specify that I was not seeking the information in this motion to compel. The reason being is there is a lawful injunction in place by the Nevada Supreme Court. I am not attempting to act in bad faith. I am not attempting to circumvent a lawful injunction by the Nevada Supreme Court. It is clear what my intention was. But LVMPD wants to say that the reason that the reason that I made that assertion was that I just don't want the information, and therefore, when time comes, if it comes, I should not be allowed to participate in the committee that looks at this evidence. So essentially, LVMPD is trying to have it almost two ways. Yes, we want that evidence. We want to show it to the defendant, and they say, well, we'll show you what we want to show you because you're not going to participate in that committee. Now, they say my investigator will, but my investigator is not the attorney. I am. Well, pro se anyway. So, and then I've just got a couple more brief points. Unfortunately, I need to report an incident that occurred a couple of times. Acts of intimidation, really. On April 7th, 2 days after the last hearing, the director for psych services came to see me, and she looked really upset. She claimed she was concerned about my mental health. And uncharacteristically upset. She frankly looked like she was in pain. And she went through a brief assessment. And once the assessment was done, that's when her demeanor changed. But again, it looked like she just did not want to be there. Then 2 days ago, a psych nurse came to see me and said she was very worried that I might hurt myself because trial was so close. I'm sure everybody here knows trial is not till November. And so I explained that to her, but yet she still said she was really, really concerned that something's going to happen to me. And she forcefully conveyed that I should be scared of something. So, and both these women in the past have been nothing but pleasant, nothing but encouraging. And now it appears that they were visiting me simply to make sure that I received a message. That if I don't shut my mouth, I'm going to be subject to constant watch. Which, constant watch, the report may know, is basically being thrown into a windowless room that is set somewhere between 60 and 65 degrees with no clothes on, 100% nude, with a thin, coarse blanket, and no books, no entertainment whatsoever. It really is, when someone makes that threat, it's a serious threat. So I am concerned, and I say this to you on the record now, because should something happen to me in the future, or something happen in my legal work, I want everyone to know that this is no accident. Second, if the DA really has all the evidence, which they may or may not have the evidence, we'll see, that I requested, then I really am dumbfounded how the DA could justify continuing prosecution of the case, unless, frankly, the DA intends to help LVMPD cover up the severity of the misconduct. As a side note, I will say that I have filed a complaint with LVMPD's Internal Affairs Bureau. So long as there's no internal pressure to go easy on the investigation, I am confident they will see the obvious misconduct here. Given that we cannot say yet that LVMPD has provided through the DA all of the material that I requested in my motion, and again, my motion was specifically in the body to compel these items, I'd like to ask the court to reconsider a continuance, but for the sake of allowing me to report what has been provided and what has not. Otherwise, I would ask that the court grant my requests, as they were not actually opposed in the response by LVMPD. Thank you, Your Honor.
Ms. Weckerly? Are you prepared to respond to these?
So I can respond to some of the claims. Certainly when he's talking about the conditions of confinement and the temperature at the jail, that has nothing to do with the criminal case. He can file a civil lawsuit to address those concerns. I have been in contact with Mr. Tellis's investigator, and I made an attempt to give a whole new copy of the discovery to the investigator. The device he provided, we sort of had a miscommunication about the size that it needed to be. My understanding is he's delivering a larger device, and we will download a whole new copy of all the discovery that we have and give it to Mr. Tellis's investigator. We did want to circle back with the detectives to make sure we got every updated report, and then we will provide all of that. With regard to many of the claims that he's making, it seems to me that the appropriate venue or the appropriate mechanism for those is to file a motion to suppress in the criminal case before this court. None of his allegations that he's currently made are substantiated. The court hasn't heard any evidence. There's no hearing. But the remedy on many of the things he's claiming, if they were true, would be to suppress certain evidence from the cars or from some of the searches, or claims that the detectives were not candid in their applications for search warrants. But none of those are before the court. In terms of criminal discovery in a case, the appropriate mechanism is that we disclose all the discovery, and if the defense thinks there's something missing, then they do a motion for a specific item or specific discovery. So from the state's perspective, all of this is a little bit premature. Once we disclose all the discovery we have, if Mr. Tellis believes that something's missing that would be covered by the statutes of criminal discovery or the constitutional obligations of the state, notwithstanding the Garmin devices, then they can let us know. We'll decide if we're going to provide it, and if not, then it becomes a subject of a motion before this court to make a determination whether or not to order that. But at this point, sort of that vague long list, sort of intermixed with civil claims, there's really nothing for us to respond to because we're not disputing that we have a discovery obligation in the criminal case.
Are you in the process of providing this information?
Yes.
Okay, how long before Mr. Tellis will have it, so I can...
My guess would be the beginning of next week. We could give the device.
So how long do you want to review it and make a determination whether you have everything, what else you need?
That'd be great, Your Honor. 2
weeks?
I think 2 weeks, well, maybe a week and a half or so. Well, I guess for what on, perhaps a bit over a week would be fine.
Okay.
So, and I just want to respond, of course, really briefly to the, unless,
Sure, go ahead.
I can't draft a motion to suppress evidence, and I cannot draft a motion to dismiss the indictment if I don't have the items that I need. And that's why I think a continuance on my motion, rather than dismissing it.
Do you have all the search warrants? Copies of the search
I don't
warrants?
have all of them, Your Honor. No. I was able to get a fair amount of them from the vault, but again, that does not include the proof that the times that the search warrants were signed by the judges. It doesn't show that.
We don't put a time. I don't ever recall putting the time down. I mean, they get filed.
Right.
Do you have the file stamp?
If I may.
Do you have the file stamp copy of the search warrants?
I do, Your Honor.
Okay.
So I'm not talking about the search warrants when they were filed. I'm talking about when they were signed. And LVMPD uses
Well, we
a
sign them and we file them immediately.
LVMPD uses a signature service, correct, to allow you to sign them, or who signs these? Who provides the signature software for the search warrants?
They come up on our computer. We review them. You can do it on your desk. You can do it at home. You review it. You either sign it or not sign it, and then you immediately file it.
So you receive an email saying that you've got to sign the search warrant?
I don't know if I get an email. Usually I get a phone call. because you have to swear in an officer.
Right, and
So
so-
no, I don't get an email.
That
You
system.
get a phone call, you swear the officer in.
Yeah, well, and we're
But I'm
talking,
assuming it comes
we're not
via
talking about
email.
telephonic search and search, we're talking about regular
No,
search
that's what we
warrants.
do all our search.
Okay, well, again, there's a total distinction between search warrant and telephonic search warrant, so regardless, Your Honor, what I'm saying is that the system that allows you to electronically sign actually keeps a log of when these things are signed. And that's the log that I'm looking for to prove that these search warrants were issued after much of this activity occurred. So it's a matter of technology, and anyone who's got that techno savvy will know that information can be obtained. So, but again, the point is that I need the evidence to bring before the court for the motion to suppress. So, I can't get to point C without getting to point B. And if this court does not get my full explanations for why I need them now, Your Honor will have potentially basis to deny what I'm asking for. So do I have to basically restate the same motion twice? Essentially,
No.
yes.
No, you don't have to. I'm going to put it on for 2 weeks, let you review everything you have, make a determination as to what you have, what you don't have, and then we'll take up the issue again.
Oh,
We'll
okay.
go through each one if you want to.
Great. Well, what I meant was I got to do a motion to compel and I've got to do a motion to suppress. But I appreciate that, Your Honor. Thank you. I guess I'm done for now.
Okay?
I really don't have anything to add, Your Honor, other than, as the court's already stated, the subpoenas that we received were invalid at the time because there was no court order authorizing them, and there was no hearing. The return date was not an evidentiary hearing. So Mr. Tellis got the standard response that everyone gets when they send us invalid subpoenas. And I don't have any opinion as to whether any of these things are admissible or relevant. So if there's a motion to compel or a motion for a subpoena, I think is the appropriate thing for him to do. A motion for a subpoena, then the DA will look at that, and if a subpoena is issued to Metro, then Metro will respond accordingly as long as there's a court order authorizing it.
Okay, and whatever Metro has, the state has.
Right.
So if
Right.
Metro is in possession of it, then, and it's appropriate to turn over, Ms. Weckerly will turn it over.
That's right. It only rarely will the defense seek something that Metro has some independent objection to. Like for instance, we heard about disciplinary records.
Right.
So that would be something that might be where I would have to appear here again. But if it's relevant in the criminal case, then, and the DA decides that it is, then of course Mr. Tellis should have it.
Okay. So anything else?
Well, I would
know
just,
we have-
I'm not sure if the motion to compel is going to be converted into a motion for a subpoena, or if Your Honor is denying it and there's another motion that's going to be filed, but
No,
just to
I'm
clarify
leaving it
that.
open. I'm going to continue
Yep.
it for 2 weeks.
Okay.
Okay?
Yep.
All right, and then now we have to talk about, because it's now back from the Supreme Court, did you all submit Metro submitted an order protocol? Did you all submit an?
Yes, Your Honor. We filed a brief yesterday, and
Okay.
we submitted
Is it
to
in
you.
your opposition?
It is. It's attached. It's the interim protocol order that we asked for to be entered earlier in the case. We've never really had an opportunity to talk about it, and I'd like to talk about it today if we could, but before
Sure.
we get there, if I could just address what you were all just talking about briefly. Our only position there, I think Your Honor
Sure.
understands, Mr. Tellis sounds like he's carving everything out that is currently protected by the two injunctions, the one entered by the Supreme Court, the one entered by this court.
Sure.
So he's not asking for any of that, but I also want to make clear that the state is not turning over anything that is on the devices. As you know, Metro has already looked at the phone. That was the subject of the motion for sanctions that we heard on January 25th. So Metro has in its possession, information that's on the phone. We've tried to obtain that. They refused to give it to us. And, Your Honor, we filed a petition for writ of mandamus seeking an order requiring them to tell us what they saw on the phone. And 2 days ago, the Nevada Supreme Court entered an order saying that they would like to hear more about that, and so they've ordered Metro and the state to provide an answer. I think it's within 21 days of that order, and then we have a chance to reply. So that's a serious issue in the Supreme Court's mind. So I just want to be on the record making sure, and I would like to have a representation, that whatever the state has, first of all, that Metro has not conveyed the information from the phone to the state, and secondly, that is not going to be included in the discovery that's going to be put on the device that's going to be given to Mr. Tellis. I want that on the record.
I'm assuming you haven't because there's no order in place yet. Right?
Right.
Okay, so, all right. So if that's not going to be transmitted to Mr. Tellis and it's only with Metro, we're fine there and we can move on to the next issue.
And well, the next issue is the protocol for doing, you know, I didn't have an opportunity to review your order. I did look at Metro's and I was going to thought it was not specific enough because the people involved have to understand, you know, the confidentiality. I haven't had a chance to review yours, so I'd like to have an opportunity to review it and then prepare an order that both parties can look at before the court issues its order. And of course, Mr. Tellis.
Okay, Your Honor.
Okay, so we're going to put this on for 2 weeks.
Your Honor, do you?
Your Honor,
Say that again. Okay, we have a date pending already of May 3rd. Is that enough time?
Yes, Your Honor, that should be sufficient. My investigator was already working, as Ms. Workley said, with her to get that done, so I can get it done early enough. Yes, thank you.
And the motions will also be continued to May 3rd at 8:30 a.m.
so Your Honor, with respect to the dueling protocols, you'll give us a tentative and then we'll have an opportunity to be heard?
Right. To object or say you want something else in there.
Would you like
Definitely
something
make
in writing submitted to you, or after we see your tentative?
That
or-
would be fine.
Okay. And when do you anticipate issuing that? Is sometime in this next 2-week period?
Before we meet again.
Okay. Thank
All
you.
right, thank you.
Thank you, Your Honor.
Thank you. We're looking at it.
You've been watching Breaking News from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.